Okay, hello guys. We'll try something a bit different this year, which is to do some video feedback. And essentially what I want to do with you quickly is to go over the two questions that you were asked in your formative and give some kind of general feedback on things that people did well and things to look out for in the future. And then at the end I'm going to do kind of some general stuff that came up, both in terms of more substantive feedback and also quite importantly in terms of potential word saving as well, because obviously looking towards your summative you have slightly more words to play with than you did for your formative, but it's still going to need to be a very concise essay. Okay, in terms of the two questions and the major points arising, the first question, as you know, was the difference between subjective and objective mens rea and why does this difference matter? Now, most people did pretty well in terms of understanding the basic descriptive difference. The problem with this question was that in order to engage with it properly, in order to demonstrate knowledge, you need to go further than simply saying subjective mens rea focuses on the mind of the defendant and objective mens rea takes an outward, if you like, perspective by comparing the defendant to the reasonable person. Those things are something I would expect as a very basic core, but people, I think, perhaps partly through not reading around as much as they could have done or for whatever reason, almost ended up making that statement and then repeating that statement in different words throughout their essay, rather than taking us into further depth, which was necessary. What I wanted from you in this kind of essay is to say, yes, that's the descriptive difference, but now let's think about what's the nature of that difference? What does that mean for the law? So essentially what I'm talking about there is subjective mens rea, by focusing on the exact mind of the defendant and their choices, is making a claim about what we should focus on and what we should blame. And that claim is essentially rebutted, or is attempting it, or is in conflict at least, with an objective mens rea perspective, which says it's more practical, it's more workable, and actually it's fairer as well, perhaps, to judge our defendant against the standards of a reasonable person, rather than attempting to understand what's going on in their mind. Now, there's a lot of literature on that, and there's also the case law on that as well. A lot of you engaged with Cunningham, with Caldwell, with R&G, but actually there's a lot of detail in the argumentation of those cases, which was at best really touched upon in essays rather than engaged with properly. As a separate point on this as well, it's worth mentioning, a number of people seem to have a confusion, or at least they weren't careful as they should be in terms of their precision of language when referring to mens rea and intention. Remember, those two words are not synonymous. So intention isn't another word for mens rea. Intention is a category of mens rea. It's a mens rea term. So within the broad umbrella of mens rea, you've got intention, reckless, negligence, and so on and so on and so on. Be careful not to use those two words as if they mean the same thing. So, as I say, the major issue for that question was really that sort of depth of analysis and getting into some detail about what the nature of the difference is and also why that matters in the way that the question asks. The second question was, I guess, more straightforwardly difficult, if you like. So this one asked, is it possible in law for the defendant to cause another to commit suicide, and should it be? And your answers here were asked to engage with the case of Dalawal. Now, for this case, I guess, again, people did in varying kind of ways, as you would imagine they would, but there were a certain pattern to a few difficulties that people had, which are again worth highlighting to the whole group. I guess probably the major one was that people read Dalawal and essentially wrote me an essay about why it was difficult to find liability in the case of Dalawal. Now, or of course, they perhaps read one of the journal articles about suicide and related offences that when you cause somebody else's suicide, and again wrote me an essay that reflected all of those difficulties. Now, for example, one of the major difficulties with finding liability for causing another suicide is thinking about which offence you're going to charge. Now, murder is unlikely. Most of the time you're talking about unlawful act manslaughter, and for that you need an unlawful act. Now, as we talked about just the other day in our lecture in terms of offences against the person, if you're going to find an unlawful act, then realistically it's going to be an offence against the person, and for those, as you know, you're going to need, for an ABH offence, for example, or even a GBH offence, you're going to need evidence of psychiatric harm. It's not enough that someone was simply psychologically damaged or upset or traumatized over a period of time. It must have translated into a psychiatric harm in order to qualify within those offences, in order to have our base crime. Now, with the victim no longer around, it's impossible, obviously, to do a psychiatric evaluation at that point. And so unless there's been some kind of prior diagnosis, it's always going to be very difficult to have that base crime in order to then say, has that base crime caused the eventual death? Now, that's a very important issue and a very difficult one when it comes to finding liability in these cases. But it is a different issue than the one of causation. Causation is a separate issue, and that's the one that your essay asked you to focus on. So to the extent that people got waylaid with the issue of base crimes and psychiatric harm and psychological harm, essentially it was often reasonable material, but it wasn't material that you could get full credit for as an answer to the question you were asked. When it goes to causation, your major issue should be, okay, imagining we have a base crime, what are the difficulties of demonstrating that that has led directly in law to death? And the big issues will be foreseeability, as was discussed particularly in Wallace, and the issues of free and voluntary actions that could potentially break the chain of causation. Now, both Dalibal and Wallace tell us that potentially suicide is not a free and voluntary action, but if we compare the actions of someone committing suicide, even in the context of domestic violence, to the actions of a drug addict who's taking drugs, in the case of Kennedy number 2, then we have to really try and tease apart, are those two people so very different? Because in Kennedy number 2, we're told that the drug addict is making a free and voluntary choice that breaks a chain of causation. So what is there a tension between those two lines of argument? And if there is a tension, which I think inevitably there is, then we need to think about which case is right, how we should resolve that tension, and then the implications of how we resolve that tension in terms of how we evaluate then the law of causation moving forward. So there's a whole load to unpack there, but it needed that focus, and a lot of people's essays went off in different directions and really didn't engage with that major theme as they should have done. The other one here that is important, as I talked about actually in lectures before, is the need to read cases very, very carefully in order to understand not just the outcome of the case in terms of guilt or not guilty for the defendant, but actually what is the legal rule that comes from that case. Now, I've talked actually to a few groups about this in seminars, and they've said quite rightly, it's a very difficult task to identify that, particularly when you're starting out in your career as a law student, right? And that's completely fine. But the answer to that is then look for sources that can help you. Now, that means textbooks, most obviously. It means case notes that you'll find in legal journal articles or wider legal journal articles that discuss a category of cases. These materials, and particularly the textbooks which are aimed to your kind of readership, they are trying to engage with the cases and tell you what is the legal rule that has come from those cases. So this is one of those situations where you need to read those other sources alongside the case in order to help you understand what are the major takeaways that you should have from this case. What are the major rules of law at issue? So again, that's I guess a bit more of a general point. Okay. Moving on to some general feedback, so things that I noticed across both lots of essays and the other markers noticed across both lots of essays. A few silly things, so for example, if you are making a proposition about what the law is, so you're saying, for example, the mens rea of murder is so-and-so, or causation requires this and that, then you must reference a legal authority. Now, a legal authority is either a statute, if you're talking about statutory law, or if you're talking about a common law rule, as the examples I just gave were, then you would need to reference a case. It is not acceptable to reference a textbook that makes that point. The textbook is taking its information from the cases and from the statutes. A textbook is not legal authority, it's a piece of secondary literature. So if you're making a claim about what the law is, you need a primary source to do that. If you're making a claim about argumentation about the law, opinions about how the law should be or could be interpreted, then absolutely textbooks are reasonable for that purpose, and indeed any other secondary material, journal articles, books, etc., etc. But for primary statements of law, use primary sources to back up your point. Another more general point, and this is one I was just really talking about on the causation question, but it applies to both, that when you're looking towards your summative essays, it is absolutely imperative that you fully understand the legal debate before you start engaging with that debate. There was evidence across both lots of essays that people were jumping to the stage of writing much too early and not engaging with the legal debate as they needed to. Now, sometimes that involved people's writing where I could tell from the way they were writing, the way they were analysing, that they were potentially very, very good and they understood the things that they had read, but they simply hadn't read enough. They simply hadn't understood the debate that they were engaging in. The most obvious example of this is in relation to the causation question, where people had just searched for suicide, found the Suicide Act, found discussion about assisting and encouraging suicide. Now, that's all very well, but that's an offence that doesn't require causation, so it's simply not relevant to a causation essay. The simplest way to understand a debate before you get going is to begin with your textbook. With a single textbook, or go to the library to get 2 or 3 different types of textbooks and find that debate within the textbook. Pretty much most of your major criminal law debates, the kind of things we ask you questions for, and certainly your summative essay questions, you'll be able to find those discussions in your textbook. So start with those and get a handle on what is the legal issue at play here. And look at the footnotes, for example. Look at the cases that are being referenced. Look at the journal articles that are being referenced. So start with that textbook. Make sure that you fully understand what is the debate you're engaging with, and then slowly work out from there in terms of using those sources that are recommended in the book to help you get some more detail, get some more perspectives, get some more opinions, and so on and so on. It's absolutely essential, as I say, that you start with that textbook first in order to understand what it is exactly that you're writing about and what's important. Indeed, if a question, as in your formative, and this you can think about for other subjects rather, as in your formative, if you've got a question which references a particular case, then one of the easiest ways to find out about that debate is go to the very front of your textbook where you'll have a table of cases, and alongside the table of cases it will reference what page numbers within the textbook is that case discussed. So one of the simplest things you could have done for Dalawal was to go to the front of your textbook, find every reference to Dalawal. I think there's probably about 3 or 4 within the textbook, and that will direct you immediately to where that case is being discussed within the textbook. So you don't have to read swathes of material. It's a case of understanding the specific debate that you're being asked about and that you need to deal with in your essays. So that's a general tip. Start with textbooks. As I say, more than one textbook is a good thing, but then move on from there in terms of the literature as well, and use those footnotes within the textbook to help you locate that reading. Related to that is, again, to simply reiterate the point that I do expect, and we do expect as markers, when it comes to a coursework essay, certainly, to see at least some engagement with academic journal articles. So one of the first things I do as I flick through is I check broadly if the references are in order in terms of scholar referencing and so on, and I'll flick to the bibliography at the bottom, and I will expect at least one relevant legal journal article to be listed within that. And then, of course, as I'm reading through your essay, I'll expect some kind of engagement with that academic debate. Now, when it comes to essay questions, it's very, very easy to integrate academic writing, and it will improve your essay because you're understanding what are the big academic arguments out there, and then you can either agree or disagree, but you can engage with them, and it will really help that depth within your writing, the kind of thing that I was concerned about, particularly for people writing that first essay about objective and subjective mens rea. You need to get that depth of your analysis, and reading academic journals and engaging with those debates will really help you. The last things I wanted to say were actually about word saving. So like I say, relatively short word counts. You need to be thinking about how to keep your writing concise. Now, for a number of you, there's stylistic issues that you need to work on in terms of trying to really pare down your writing a little bit to make sure it's clearer and more concise, separating out big long paragraphs into more manageable shorter paragraphs with clearer headings. Use of subheadings and so on, again, can save you word count sometimes if you just break your essay up that way. Rather than having to write long introductions to different sections, you can simply use a subheading to do that work for you. The Writing Clinic is a very useful resource within the university, and again, I would encourage people, if you have any concerns about your writing, this is the time to do some work on it. This is something that will affect you throughout your degree in all of your subjects. So if any doubt, and particularly if you've been encouraged within your feedback on your essay, please do make use of that service. It's good for all of us sometimes to have that kind of check-in on our writing style. Other more general points on this would be Osceola referencing. Some people are referencing things in slightly weird and wonderful ways, but often using many more words than they necessarily need to. So they could, if you use Osceola properly, then you can bring that word count down. We have links obviously on the Birmingham website to Osceola referencing, but if you just Google OSCOLA, then you'll find most universities will have links to various Osceola guides. The easiest one for you to use is they have a quick style guide, Osceola referencing quick style guide. If you Google that, you'll find a single page which will give you the basic information you need: how to reference a case, how to reference an article, how to reference a statute, how to reference a book. So make sure you have that single page on the desk next to you, so as you're writing you just make sure that that referencing part of your work is correct. 1, to keep the words down, and 2, not to lose silly points. Another thing that a lot of you I think could use, some of you are already, but it's a sensible one when you have short word counts, is rather than writing out a full reference every single time and using up lots and lots of words like that, if it's a source that you've already referenced, it's perfectly acceptable to simply refer back to the one above. So again, you might need to Google around this to make sure you fully understand it, or indeed come and talk to us in our office hours. But for example, if the footnote directly below is the same as the one above, it's the same source that you're simply referencing again, then there's a technique just simply called IBID. So you put IBID, which means the same as the reference above. Or if that same reference comes up much later in the text, then you might mention simply the name of the author and then in brackets N1, i.e. back to note 1, that's the reference. All you need then is the name of the author and then a page reference if that's necessary. So again, these kinds of techniques, if you look for them, quick reference guides in terms of using IBID, using cross-referencing in terms of N1, N2 or whatever it is in brackets, those again can save you quite a lot of words, which will then in turn allow you to put more detail into your main body of your essay. Another one, very, very common here, but again worth reiterating, is the fact that when you're talking about a case, there is absolutely no need to tell me the facts of that case unless they're being used for a purpose. So if you're referring to a case simply because it makes a certain point of law, so for example you're talking about factual causation and you use the case of White, I don't need you to tell me the facts of White. It doesn't really add anything to your analysis. You can simply say the but-for test footnoted the case of White as your authority. Of course, sometimes you will be using the facts of a case. You'll be saying our scenario is more similar to this case than it is to the other case, and so therefore it makes sense to tell me the facts of the case in order to make that comparison. Or in an essay question, you'll be talking to me about the fairness of a particular outcome. And there, of course, I need to know the facts of the case in order to understand whether what you're claiming is fair or unfair. So sometimes necessary, but always ask yourself that question. Do I need to give you the facts of this case in order to make the argument that I'm trying to make? And if the answer is no, then simply don't do it. Referencing to the case name is sufficient. And again, that will save you words. What we want to see, and what we're seeing a lot of, but we want more of, is your ability to lead me through. You are in charge of your own essay. So you're beginning your essay by saying, this is what the question's about, this is how I'm going to answer it. Then you have 1, 2, 3, let's say sections within your essay where you're taking us through as your reader the various important points within the essay, leading to a sensible conclusion and demonstrating knowledge, demonstrating your ability to analyse, demonstrating your ability to evaluate. You do all of those things and you'll do very, very well, I promise. Come and talk to any of us. As I say, I'll talk a bit more about this kind of thing in the very last lecture of term when we're going to be focusing on essay writing, but this is just a general overall feedback. Okay, thanks very much. Bye.